Hey, good afternoon, everyone. Thanks a lot for joining this panel. It's Streinz, it's Florence. And very happy to be here in Taiwan. It's Typhoon season, and we'll see how stormy this panel is going to get. And it's called Towards a Resilient Storm Defying Global Supply Chain, Navigating Geopolitical Shifts and International Economic Law. As you can see, it's a complex topic that we need to address with a packed panel that features 6 presentations by 7 authors, presenters, thinkers. And the spirit of the SIEL conference, we try to host this discussion as dynamically as possible. So it will be relatively short presentations, followed by discussion among the panelists and hopefully also with all of you. Now, without further ado, I'll hand it over to the first presentation. Maybe over here, who comes from the Office of Trade Negotiations here in Taiwan. Thanks a lot, for yours.
Hello. Hi, thank you so much for being here, and thank you for that very kind introduction. I would like to begin by addressing that I am working for the Office of Trade Negotiation at the moment. I was when I signed up for the conference. Anyway, the title of my research is Geopolitics, Undead, Power Blocs, Critical Mineral Alliances, and Lifeline of Multilateral Trade Order. And what I intend to do with this research is I would like to use critical minerals and its and the industrial policy on 3 levels: national or unilateral, if you will, bilateral and regional cooperation. The efforts by so many countries around the world these days to highlight, especially critical mineral and its trade as a strategic commodity, to highlight the importance and the almost resurgence and geopolitical concern instead of purely driven by economic incentives. So I think what I aim to do is I want to refer to all of these legal instruments, and by identifying some common things that we can find from all these legal documents, and we can deduce that a lot of we can imagine a lot of different policy objective or incentive that would prompt all these countries to impose measures like this. But what I aim to convey with this research is by putting this issue back into the context of the geopolitical context, is especially as a form of decoupling the risking reglobalization. And I have 8 minutes. Okay. It is revealed that the multilateral trade order or WTO law, as we know, so far, we can reveal its limitation as to why it isn't enough to address international trade policy today anymore, and how we can move this discussion forward. And so my presentation, if I have the time, I would like to divide it into three parts. The first part is the who are the trading partners we are aiming, we consider safe, and we should collaborate with, as we can, and who are the people that we are risking from, through I would like to refer to U.S. Chips and Science Act for this one, because you'll see in a second. And the second part is I would like to point out there's a shift in how these countries are enforcing or not enforcing, which is in effect kind of forming this little power blocks, power cliffs, if you will, in securing the supply chain and ensure that it is not disrupted by geopolitical tensions, especially war or other regional disruptions. And lastly, this is more of a question I would like to pose to the audience instead of an observation I already have. It's I would like to invite all of us to look at these, to what extent the WTO framework that we are so way too familiar with, to find violations, and if so, if there's a violation, what kind of justification, what kind of subjective or objective policy goal that we're aiming to achieve, and to what extent is this framework can help us address a trade the modern trade policy that is no longer purely driven by economic incentives. So I would like to I want to begin by highlighting some key traits for critical minerals. This might not be a comprehensive definition, but for the purpose of this research, I would limit critical minerals to those that are critical to economic or national security, in the sense that either it is a essential components in manufacturing, which in turn creates a vulnerability to disruption. For example, if we can use Russia-Ukraine war and of course the current rivalry between US and China, two of the biggest powerful economies in the world currently, we can already see this trend that US has been planning how we can readjust, but how we can sort of strategize and relocate, repurpose our supply chain, so we can reduce the dependence on China very specifically. But on the other side of the spectrum, we can also look at, for example, critical minerals such as lithium or cobalt, and these components are by far irreplaceable in production of a lot of equipment that is important in the renewable energy industry, and for example, electric vehicles and batteries, AI, quantum computing, you name it. But okay. Okay. So the first of all, so with the very limited time, what I would like to focus on is, for example, U.S. and Chip Science Act, how they cropped out the people they would like to conduct trade with is what they call the foreign country of concern. And even though the concern part is never it's not like open to discussions to the world, but we can see very similar instruments in, for example, national security law, where they would use non-allied foreign nations, and specifically point out North Korea, China, Russia, and Iran. So from this list, we can already kind of deduce that it is a very straightforward reference to the trade partners that they consider not to be. Oh, can I just say one last thing? So something else they would like to do in fact is they would. So for example, in Canada, UK critical minerals supply chains dialogue or US-Japan's critical minerals agreements. What we use is when we refer to, for example, ESG standards or labor and environmental standards to in effect actually block out countries like China or Indonesia, which with lower labor standards and in fact like actually not allowing them to export these critical minerals. I'm so sorry.
Thanks a lot for your presentation, which of course deserves much more time than we have here. So I think that goes for everyone here. The panels want to get deeper into the issues. I would encourage you to approach the panels also after attending this software reception to go deeper. What we first maybe was, I think, one snapshot into an issue with the minerals governance, which is for and what kind of governance instruments are emerging to address that critical issue in global supply chains. That way, she gave us an example for something we call the supply chain law. The next presentation by Christian as a deeper dive into how to conceptualize supply chains from a legal perspective. For instance.
All right. Well, thanks everyone for thanks, Charles, for the lovely introduction. So my paper stems from a couple of observations. We've seen a lot of moves now in the legal environment, domestically and international in particular, to have obligations that are specifically aimed at global chains. We have due diligence laws, we have the rigorous labor law in the United States, that several global value chain obligations in FTAs, such as certifying palm oil with EFTA Indonesia FTA. We even have an agreement specifically aimed at supply chains, the IPEF supply chain agreement, which creates certain rules of disruptions that might occur. Now, if we look at all these formations, we see a couple of key similarities. One is that they're largely responsive to particular market failures. It's essentially a game of whack-a-mole. Certain market failures occur, we create certain rules that try and address them. But one of the issues that emerges from this very ex post approach is that it largely places the onus of implementation effectiveness on firm buy-in. And here we have certain carrots. IPEF supply chain agreement is a very good example of just that. Certain advantages of corporate initiatives there, or certain sticks, and we've seen especially with due diligence laws. Now, this seems to essentially imply that there's some sort of separation in the roles of states versus firms. Firms are the main managers of global value chains, and that states are simply there to intervene where the market gets wrong. Well, my paper tries to really conceptualize some of these issues, and it makes three claims. My time runs out, and happy to answer questions about that. It's wrong. The first one is there's no absolute normative separation of governance functions between states and firms. It's essentially it's a pluralist scene, characterized by substantial overlaps of governance powers, and a perfect substitutability. Second, where beyond this area of overlap, states actually have a lot of room to play with further. That's essentially when exercising some of their structural roles. And we have a long history that represents just that. A pretty dodgy history regarding the textile regime. And finally, we can still achieve some of these functions, even if we don't exist in the advanced post-war world. We need to adapt it to the modern day nature and structuring of global value chains. So I'll quickly go through all these things. Such. When it comes to the first point, if we're talking about overlap, we see there's especially a lot of overlap when it comes to all these ex-post functions. States and firms have very substantial roles when it comes to, for instance, standard setting, or one of those types of activities. You also see this when it comes to sometimes liability issues. States have, of course, certain jurisdictional limitations, especially when it comes to enforcement and monitoring. So we've seen a rise, for instance, in grievance mechanisms, and there's a large literature in the business of human rights movement that has emphasized on how those should be worked with. We've also seen this when it comes to, let's say, the building of certain important infrastructure, physical infrastructure. Now, this would, of course, suggest that there's some area of overlap, but let's not kid ourselves. It is not a substitution in any sense. There are key distinctions that exist between each of these governance models, where there is overlap. States might well have many more stakeholders they care about, as opposed to the private interests of firms. Firms do not have necessarily the capacity to overcome some of the transaction costs. You have a disruption. States have jurisdictional limits, which firms, whenever they invite activities, don't necessarily have. But also, states have a lot more powers, those police powers that extend far beyond this. And also, states set the conditions of the game. They set the legal infrastructure on which global value chain governance really does emerge. And to overcome some of these issues with unilateral enforcement, we've kind of seen, let's say, with due diligence laws, it's good to see some of the efforts of collective action in the past, just to see all this story as it has developed. So, very briefly, the history of the textiles regime is perhaps one of those no-go areas that was said in one of the past panels today, which focused on essentially the adaptation of textile regime following the development of textiles manufacturing, especially within the global south. Now, this led to fears of market disruptions, so certain arrangements got created. Three sets of these. Cotton textiles arrangements that existed largely from the mid-60s, the early 60s to the mid-70s. The multi-fiber arrangements, 4 of them from the 70s to 1994, and then the WTO, the Agreement on Textiles, third. Now, each of these arrangements have some general characteristics. I won't go into the details of each, given the limited time, but it's somewhat worth mentioning. They had certain rules that created forms of interventions. They had wide scopes. They were, of course, quite disruptive, especially to the global south, especially to the Asian tigers. And what their implications were that they had also created very substantial legal infrastructure, textiles monitoring body, and textile surveillance body. All of these had very significant repercussions overall as the regime had developed. And essentially, they led to the geographic allocation of functions, of productive activities, not just being limited to states that might have a competitive advantage, so to speak, but it being forced to spread, right? Because it needs discriminatory safeguards against ones that are too successful. So that overall led to certain developments. I'll just quickly mention one such example. It's, for instance, the fact that within the Asian tigers, as upgrading occurred, activities that were more labor intensive were delegated, for instance, to other states. And that led to the emergence of some of these value chains. This all coordinated with some activities with the creation, for instance, of need buyers, these massive firms. Now, I will talk, if anyone is interested in the third point, I'll have to answer it during the Q&A. Thanks.
Thanks a lot for this very infrastructural account that also might have to think a bit about governance innovation response to whether or not textiles is example to emulate. It shows us that it's possible to think about different institutional arrangements. The question, of course, is not only right institutional arrangements for the kind of supply chain challenges that we face today, sector separation from critical minerals, to semiconductors, which will be our next presentation by Ching-Fu based on this paper together with Han-Wei. Ching-Fu, the floor is yours.
Thank you very much, Thomas. It's a great pleasure for me to share with you doing research that I have been working on recently. So today we'll be sharing from the Taiwanese perspective as to how Taiwan is tackling with the regulatory dynamics in the midst of U.S.-China rivalry and semiconductor supply chain. And as you both of us know and learn already from these roundtable discussion, we know that semiconductor supply chain has been internationalized in the past several decades, and now it's kind of developed into a really sophisticated division of labor into roles located in different countries and specific companies like TSMC, Samsung, and many other companies. So I will like into details here, but this is just a slide to show you that how the semiconductor supply chain has developed and transformed from 1950s to nowadays, seeing that the different kind of division of labor from software, IT providers, fabless, design house, manufacturing tools, and other kinds of IT-related stuff. So now our paper is really focusing on this kind of choke point economies, how they are in position, a critical position, irreplaceable in a way, but also facing double-edged situations coming from just the market in China, domestic industry needs, and as well as the pressure coming from the US in terms of how we can constrain the development of tech rivalry in China. So this is a kind of like how we unpack the choke point economies here, as we can see from design, fabrication, and packaging and test. You see different companies are actually different nodes of the supply chain, which gives a strong influence on the supply chain and leverage to serve as gatekeepers control. So you see like different like ASML, we talked about this in the morning, software in the US, materials or chemicals companies in Japan, TSMC, and so on, etc. So these kind of choke point economies, they are put together with their their home countries are facing dilemmas in the context of US-China tech war rivalry. So you see different tech teams and different kind of measures and retaliation taken by US and China and other choke point economies in the middle. So some notes to share at this moment. First of all, we talk about the double-edged nature of this kind of choke point economies, because given their influence along the supply chain, they can be leveraged as gatekeepers, but they are at the same time vulnerable to geopolitical risk by China or US. And US in particular has been weaponizing this kind of flow and territorial measures to impose their own preferences on systems in Taiwan and Korea. Second of all, the kind of unilateral approach driven from the US domestic interest is also clashing with the competing agendas and competing interests in different etc. And there seems to be a lack of real collaboration amongst economies because there are not similar goals and similar interests here. And then in the future, maybe there will be another layers of uncertainties over time. And in particular, we talk about Taiwan, TSMC's dominance in advanced chips, right, 9% or so, gives Taiwan structural leverage here. And at the same time, Taiwan is also being put in a really special position here, facing market pressures from China, domestic industry needs, and also US pressure. So in the past few years, Taiwan has been trying really hard to find a balance between different administrations in the US, US-China rivalry, etc. But now, given the natural kind of ad hoc kind of negotiation-based or what we call transaction style of US leadership, in a way, Taiwan is really left with really to run to align with control. So we see different angles and different dimensions of export control related things in Taiwan. Along the four dimensions here: investment, talent, products, and tech IP, etc. Most importantly, we have the device national security law, which created a list of national core key technologies, so as to provide an additional layer of protection. And then till this last month in June, then we updated our HTC entity list, which mirrored what's already there in the US. So kind of bringing system much more in line with the US export control system. But there are still some differences. We want to know about this when we have our Q&A. So skip many of the slides here, but this is just a few slides to let you know that how different countries are aligning their export control or semiconductor related measures to the US. To the top is the US domestic law, and the other is how it is interacting with other countries' measures. So we see that the US is taking measures already in Trump first administration, and in the administration there are more measures being taken in the US, but also more kinds of alignment with different like-minded countries, including Taiwan. And in Trump too, Trump's second administration, we see more coming, but then some like more vulnerable geopolitical economies are also been pushed by the US to adopt the export control system with the US more closely. So to conclude here, so some quick notes to note. So we see there is as a matter of fact increasing the line export control system, but not like increasing the line interest across the supply chain, especially among the US and other tropical economies. And the so-called reframe, framing province, silicon scrap statecraft is largely taking place outside of the multilateral trading system. It's more unilateral or club in nature, ad hoc or kind of Southward approaches are proliferating, changing and repetitive web of norms that companies have to keep up with, which they have trouble with that. And so what we see, while this is a little bit idealistic, but we call for a more kind of orchestrated, not really fundamental, but orchestrated strategy among so as to work together on for example, information sharing, so as to kind of harmonize the work to integrate their interests and agenda, so as to make a balance, proper balance. Thank you very much. And this is how the op-ed so I have a paper on trade, which George served as a special issue editor to talk further for decision.
Ching-Fu for deep dive into the methods around semiconductors, machines as a legal technology that affects supply chains. It's also a study of unilateralism, solutions, worlds where structural dependencies might get recognized. I'll use that as a segue to the next presentation, which will be Yoshiko from Nagoya University will tell us about the use of battery cost provision.
Thank you so much. I'm Yoshiko from Nagoya University, Japan, and the paper I'm working on is about the EU battery passport, and I'm going to talk about this EU issue as a non-European nationalist, because actually there's some EU and Brussels effects on Asian batteries purchased for Japan, but so for Korea, South Korea, and China. And before starting, I'd like to ask how many of you have heard about digital product passports? Thank you so much. Okay, thank you. Well, I think if you're from Europe, you have heard about this digital passport in the context of circular economy agendas backed up by EU battery regulations or EU eco design regulations. However, I think that this digital product passport is still new in this trade law field. But if we look at scientific literature, there are lots of paper on digital product passports in the context of material engineering or smart manufacturing, industry ecology. So today I'd like to see how the concept of digital product passports can fit into trade law as a concept. So what are digital product passports? In general, it is explained as a combination of product life cycle data plus technical IT infrastructure to facilitate data gathering, processing, sharing across supply chains. So it used a lot of IoT, blockchain platforms and sensors. And for EU, battery passport is the first use case, but the EU is planning to expand the scope of the products to textiles, electronics, chemistry, or construction materials and so on in the future. And there's two objectives of product passports. First one is about improved sustainability product management to collect product information, including sustainable sourcing, carbon footprints, and human rights, environmental due diligence. And the second objective is related to geopolitical concerns. We can secure the supply of critical raw minerals for batteries, setting up by this digital passports, and we can increase recycled contents in the future. And the second question that should be asked is this about a trade issue? And yes, it is about trade because establishing a passport is a requirement for placing batteries on the EU market. So there are going to be huge sustainability information requirements on trade, and it will be make a lot of external trade impacts on foreign producers as well as suppliers. And in the trade law context, this product passports can have two dimensions. First is product regulation, and second is data governance. Product regulation means we should think how this passport can fit into WTO law, and some may review have reflected US law case, labeling case, livestock, which address a lot of reporting and verification issues. And the second dimension relates to data governance, which means legal arrangement for data access and data process for trust, which means trade secret or business confidentiality. And this includes how much the question, how the stakeholder are willing to share their data to supply chain. So quickly, there is the one time. The first question is how these product passports can fit into WTO law. And we can think of the agreements in this regard, and there are three criteria for technical migrations. And I think two first criteria do not have a problem, but the key criteria is whether digital product passports place product characteristics. And there's two ways to think about. So product information required under the passport, such as carbon footprints or due diligence, is the means to identify products. So in the sense that can be characteristics. Another way to think is product passports are physically presented with products as a barcode and QR code. So this can be equivalent to the product label. So in this sense, three criteria of technical migration can be met. And the second question goes to legal test under PET, Article 2.1. And the question is, of course, whether there are regulatory distinction between imported batteries and EU batteries. And the question goes further, according to the Article cases, whether this distinction are applied in country. And I haven't looked at in detail yet, but there are similar facts that can affect this legal test. For example, some kind of increased cost for coordinating suppliers, or burden of implementing new technology or new architecture to operate the passport or something like that. But all depends on how the implementation goes on in the EU, because currently the implementation in the EU is still in development. So even you see that EU is very hard to implement. And to finalize my presentation, the last point is about data governance. And there is already collaborative data sharing activities between EU and Japan, because Japanese producer has to collect information, their supply chains, and send it to European side to sell their EV cars. So Japanese battery and car industries already started to provide data traceability services within Japan. And this is actually adopting the case of adopting battery passport. And this is backed up by Japanese government, which provided a data platform, which is called Uranos ecosystem. And on the other side, in Europe, there are a lot of projects to implement battery passports, and probably Catena X is one of the famous one. And recently, Japanese government and European Catena X has made a agreement to secure cross-border interoperability in terms of data. So to wrap up, so maybe we should think of how we can create data exchange ecosystem in the future if it is successful. So not only between EU and Japan, but EU, Korea, and EU, China, and to create a global ecosystem. Okay, I stop here. Thank you so much.
Thanks a lot. Well, the presentation, China is how product regulation recently goes hand in hand with data regulation. So appreciate the emphasis on the infrastructures that enable these kinds of data exchanges. But no infrastructure works without labor. In the next presentation by Rohan, we will talk about labor management and the challenges. Rohan, the floor is yours.
Thomas. So my paper takes a different view of the panel P, which is resilient global supply chains, and will explain how this is linked to structural labor adjustment context of finance. So when we talk about resilient supply chains, also includes diversification of supply chains, which means want to put in more number of countries are willing to integrate with the supply chain, balance, which would entail again asking them to open up their economies, liberalize their trade. Larger countries like India, Brazil, which have been more protected economies, find it difficult to do. So the question here is, how do these countries open up, and how is structural labor adjustment relevant in this context? What is structural labor adjustment, and why is it relevant for developing economies? So when countries liberalize their trade, there's reallocation of factors of production, including during this period of reallocation and transition, workers move from less efficient import competing industries to more productive ones. And generally, these workers need to be supported in terms of income, compensation, they require skills, reskilling programs. And also, we need to create more jobs to enable them to transition to new jobs. Now, this process is structural labor adjustment, which invariably follows trade liberalization. And we can also say that this is a necessary spillover to trade liberalization. The question is, governments want to minimize this period of adjustment, which is also known as adjustment cost or adjustment duration in economic terms. The governments endeavor to reduce this duration to maximize gains from trade. There's also a political side to it, because the longer the adjustment duration will cost, there's domestic erosion in support of trade liberalization. So countries would want to minimize cost. Otherwise, what we see in the case of the US post-China trade shock is an example. Now, how do countries minimize these trade shocks? Paper identifies two policy support pillars. One is the internal mechanism through internal domestic labor market policies, which is the primary tool because governments, it is acknowledged, are more capable of handling their domestic issues because they are sensitive to some national issues. Also, there are trade capacity building tools which are external in nature, and they have played a critical role otherwise in helping developing economies integrate with the global trade. So, how have these pillars performed? Because for paucity of time, I won't get into details, but just to give you an example, GAMs are general adjustment measures which refer to domestic policies. These policies in the context of domestic economies have not been very effective because informality is one of the key denominators which cuts across all developing economies. Now, why do I say so? For example, say a compensation-based scheme like an unemployment insurance scheme presupposes the existence of formal employment relationships, which is not possible in formal economy. So I leave that to that. And then moving to PCBs, which are trade capacity building initiatives. Again, these are external in nature. They have been very effective insofar as helping countries formulate trade strategies, trade negotiations, and also build trade-related infrastructure. But the last stage, which is the labor adjustment, which follows trade liberalization, is something which has been blind spot in PCBs. I'll give you an example. If you look at this data, this is aid for trade data for a particular time span. If you see, AFT does acknowledge trade-related adjustment as one of its core pillars. It's mentioned, but there is no expenditure on this account, which highlights that it has been completely non-existent. Moreover, what we see in recent years is there has been a more transactional approach with respect to capacity building initiatives, as US must have seen as dismantling US aid, and EU is also looking for mutual benefit in the sense of what it can get from an investment rather than considerations. So the paper proposes a new mechanism of maybe collaborating PCBs with domestic policies, such that instead of having a unilateral discretionary mechanism to support domestic labor market policies, we can have something which is mutually agreed, legally binding, and linked directly to trade liberalization or trade agreements in particular, so that they are more targeted. And to achieve this, we propose 5 models, 5 templates based on what we have experienced around, and also what we have based on those experiences, what we have suggested. The first one is based on a quid pro quo arrangement, which is the model of lots of collaboration where countries gain from each other. Usually would work in cases where developing economies have large markets as a bargaining leverage. And a very good example is the recent EFTA-India Trade Economic Partnership Agreement, where EFTA countries have agreed to invest $100 billion for a period of 15 years to create 1 million jobs. This is legally binding, and if after 15 years they review and find that the goals have not been achieved, India can take commensurate action, remedying measures to withdraw equivalent concessions. This is one of a kind, and there are more templates which are being followed along these lines. For instance, a tech for tariff arrangement, where countries agree to build capacities in specific sectors they are looking to open up economies, and developing economies open up their economy and reduce their tariffs accordingly. But not all countries can afford this. So smaller countries can look for complementarities, as I've suggested in the next week, where countries can look for opportunities to gain from each other. For instance, developed countries are facing skill shortages and also aging population. At the same time, developing countries are oversupplied with labor. So there's an example of recent India-Taiwan MOU, where they have agreed on construction, agriculture, and manufacturing sector, where Taiwan has agreed to train workers and employ them, which results in formalization, creating formal sector jobs for Indian workers. Then we also have an option of linking adjustment assistance with trade agreement, like a trade adjustment assistance in the US. It was tried in the case of NAFTA in 1990s, and which can be actually incorporated within a trade agreement, which is a win-win for both the parties, because one party gets to actually open up the economy in return for getting their workers trained and compensated. So the other two, actually, for positive, again, I think I'm running out of time, but there could be unilateral commitments, as US has done in the case of USMCA for Mexican labor standards. Or we can also think of incorporating labor-related standards. There already is an ILO decent work agenda along with ILO Declaration on Globalization. So on lines of what we have core labor standards in trade agreements, we can also link them. We do have these provisions, but these are best endeavor clauses right now. So these need to be more binding, or maybe. Thank you.
Presentation, which also encouraged us to explore elements. So other international trade law was clear as counter-regulatory, deregulatory, meta-regulatory regime. We could maybe experiment with ways in which new kinds of governance arrangement have any to address trade liberalization, supply chain construction entails. The background of this, I think, we also see the distribution of trusts that makes this sort of presentations, and sometimes that leads to disputes at the tail end. Final presentation by Yue, which is based on the paper is Han-Wei, will lead us to that topic. So how the changing geopolitics affect this question before it's
Thank you, Thomas. As you have mentioned, if one of us is doing transactions, it may very possibly go through whatever we have discussed today. And unfortunately, if this transaction is not going well, then you may have a dispute, and you will end up with dispute resolution. And one of the methods is arbitration, and here I am. I know we are very close to dinner time, and everyone is getting a little bit sleepy and tired after the discussions. So instead of telling you what my research is about, I'm going to share with you a case concerning jurisdictional competition between national courts and arbitration. And I hope that you can find this interesting. So basically, in 2020, Russia introduced a new provision into its arbitration procedure code, Article 248. This provision allows Russian courts to assume exclusive jurisdictions over disputes involving sanctions and sanctioned parties, even if there is an existing arbitration agreement. And as we can anticipate, very soon the parties started to evolve this provision to stop arbitration proceedings predominantly seated in jurisdictions that are imposing sanctions against Russia. However, in Lind versus Ras-Cam Alliance, this is a case, a Russian court granted RCA, which is a Russian company, granted its application under this provision to stop Lind, a German company, and its subsidiaries from initiating and continuing arbitration seated in Hong Kong, which is not a jurisdiction that is directly imposing sanctions against Russia. So in response, Lind thinks, okay, I need to do something. So Lind, this company, turned to the Hong Kong court, and it obtained an anti-suit injunction ordering the other party, RCA, the Russian party, to stop taking any further steps in the Russian court proceedings. So this is one of the many examples, and it shows how state-induced retreat from international arbitration commitments can lead to jurisdictional battles between arbitral tribunals and national courts. And as we can see from this Lind case, this goes far beyond a battle between a jurisdiction that is imposing sanctions and a jurisdiction that is being sanctioned because it involves a quite neutral jurisdiction in this case. So Han-Wei and I analyze these recent challenges to international commercial arbitration in the broader context of geopolitical changes. So this is our research. Han-Wei is apparently level-heading today on this panel. So we focus on how economic sanctions, blocking statutes, and other relevant matters are influencing and sometimes even reshaping international arbitration. And we use a tour of lawfare, which has been defined in the literature as the use and sometimes even misuse of law as a substitute for traditional military means to achieve strategic objectives. And we find there are, broadly speaking, two categories of challenges to international arbitration. The first category is state-induced challenges. Lint is an example of this. So basically, you see a state directly stepping into and sometimes even intervening into arbitration. And the second category, we focus on challenges that are not directly for the states, but are triggered by sanctions and countermeasures. One of the examples is how to interpret arbitration, how to interpret contractual clauses involving, for example, force majeure, where you have a party alleging that my so-called breach of contract is actually because of my compliance with sanctions or otherwise countermeasures. So by showing these two categories of interference, challenges to international arbitration, we find that now the geopolitical tensions are spilling over into international commercial arbitration between even private parties, which is supposed to be an area that is free from state interference. So before we talk about arbitration's resilience, we are seeing that arbitration needs to accommodate business needs. But now, if we're talking about arbitration being resilient, we're actually talking about not only business needs, but also how to accommodate these geopolitical changes. So this is basically about our research, a very short disclaimer that what I'm sharing now is not relevant to my work at Ching-Fu International Arbitration Center. Thank you.
So Han-Wei was mentioned, very mentioned author was Ching. Anyway, do you want to add anything to my presentation? Okay. So I'm curious that actually I'm going to ask questions. Are there any questions about the panelists or you think about? Okay, see, Wolfgang is a question. Excellent way that's good. Wolfgang's a question. Think of Mike. SIEL SIEL is the fight valve. So those who don't know you yet, get to know you. You read those what? Thank
you very much. Fascinating panel and a lot of ground. One of the themes that I at least picked up on this session. We're all trying to look for analogies, maybe the best thing law is the Streinz challenge of great supply chain. My question is, there's something missing at least from the first one. And that is the rise of this national security and maybe minerals is obviously recently planting. Same thing for semiconductors, where we use. So to what extent is that these institutions, these precedents, from that field crowding out recruits our presence? To what extent should we be thinking more about what nature and these types of supply chains within traditional alliances, as opposed to the pure precedents, managed trade precedents going back to the textile lanes? So are we really looking for the right institutional precedents? National security and defense.
So nation law as the group, trade law. I think the question was probably the Indian ways reflecting on one person mentioned. What is that of the governance arrangements that you study able to address the threat towards stabilization? Starting with you and then with actually from the way that there was this question, from our perspective.
Thank you so much. And this is a great, amazing question. This actually like allows me to like finish the part that I wasn't get to before. So thank you so much for doing that. And the short answer to this, I would say neither or none of these institutions are equipped with the precedents or institutional instruments to deal with what we're dealing with today. I think we can I think we can always trace back to 2010s where the WTO has at least 2 cases about China on actual restrictions and other forms of trade restrictions on critical minerals and raw materials, etc. And of course we can hold on to the presence we set at the WTO and at multilateral trade order. That's the legacy, of course. But so back to your question, should we look more to NATO or Quad or other international organizations or institutions that specialize in national security or the more traditional international relations specialties? My answer is no. So what makes critical mineral an interesting case is you cannot actually identify one policy objective was why or how we're doing this. In terms of critical minerals, you can at least say, okay, we have pressing climate change concern, and hence we have to secure a supply chain in terms of this critical minerals to make sure that global industry as a whole is moving towards solving climate change and we're substituting fossil fuels and other not environmental friendly methods. You can say that, and you can say, okay, this is one country securing its national interest in economic development because it's trying to either secure its place in emerging markets of electric vehicles or, again, solar power, wind power, etc. And of course, but none of this actually answers the very question. Okay, weaponized interdependence has become a new problem, but is it really the fix that we say, okay, national security exists outside of traditional international trade concern? Therefore, we exclude this. Therefore, it's okay, and then we go back to exceptionalism or the tools that we are already put with. And short answer is no. Long answer is I look forward to your contribution to the. Thank you.
I'll go first and then I'll give the floor to Wei. If you was done for that really tough question, I would have like two quick notes. One is the fact of how the lines between national security, economic security, and technology security, how the lines between these concepts being blurred by different competing agendas in US-China rivalry, and as well as the rise of AI and all kinds of technologies. But my understanding is that this kind of blurring lines is not really just happening years before this year. It's actually had been there for a long time. We can think about the Cold during the Cold War, and then after the Cold War, we have the Wassenaar arrangement. And in terms of the governance of dual-use technologies or products and the potential security concerns, there has always been a layer of security concern from Cold to Wassenaar to now kind of messy, what I call a messy news ball of different bilateral deals driven by US unilateral measures. And then sometimes the layer of security concern is thick, like the Cold War period. Other times the layer of security is pretty thin. And now it's like really messy in a way, right? It's not coordinated. So there's always a layer of security concern there. And then how different states are playing with or framing the idea of security will be subject to more debate. And as our paper mentioned, that there needs to be a stronger or more orchestrated strategy in terms of how we frame security altogether. And that leads to my second point about the dilemma faced by choke point economies, especially in the Indo-Pacific. Maybe not the Netherlands or those our friends in the European Union, because in those Indo-Pacific choke point economies like Taiwan, Korea, and Japan relies heavily on U.S. support in terms of stands like a really hardcore security issues, right? So to what extent can we ourselves define our idea of security, security that we want, and how to draw the line between national security and security or security. So it's really tough, especially for a tough question, especially for Indo-Pacific.
Great. Thanks a lot, Bill. Do you want to add anything, Red? So one interpretation, one first question could be to ask you whether you think that the shift that he highlighted will be good for arbitration, whether it would create disputes the right of arbitration, whether it's bad for the province out of eliminates the space for business activity, then this international space relies on the exceptional arbitration. You think it's also now?
Yeah, very quick. Thank you so much to us. It's an excellent and very challenging question. I think now the biggest problem is that if national laws and national legislation will allow this national security or even sanction-related disputes to go to arbitration. So in our research, we found that there are basically two approaches. The first approach is which was adopted by the Italian Court of Cassation, is that they denied the arbitrability of a dispute involving sanction against Iraq, if my memory serves me correctly. So basically, they are saying that from now on, all such disputes, you cannot go to arbitration, even if you have an arbitration agreement, and this is about a contract between two parties, between two private parties, or a country that is acting as a private party. You can just not go to arbitration. The second approach is that they allow this dispute to go to arbitration. For example, the Paris Court of Appeal and the Switzerland, the courts in Switzerland, they took this approach, but they will afterwards, so after you have an arbitral award, they will examine your award to make sure that the result of your award comply with public policy. And by saying public policy, this may include those sanction-related issues. So basically, you have the control beforehand. Otherwise, you have the post-award review.
Just a quick one, actually. As a most papers, I have some common things I can draw from. The one we can see sometimes it's not so much about whether or not we have the same idea of security. It's more about the structured power. We could not just focus on probably just traditional international lawyers. We have like rule-based system, but we have to draw some lessons from scholars to think about how U.S. controls the structural powers in the context of international commercial arbitration. See, EU and China, they do have the Blocs statute, so that they try to maintain their sovereignty. They try to push back the extraterritorial effect of the U.S. sanctions through natural power, but they do leave quite a leeway to member states to interpret whether or not you want seriously and how you impose penalties, etc. So at the end of the day, you can see the European Union still, at least at the member state level, is quite still soft because they do realize the risk being kicked out from the SWIFT system or be penalized by the US anyway. And that's true for the Taiwan and TSMC Semiconductor as well. We are subject to the structural power of the US to the extent that US technology is still involved.
Are there more questions from you? So now I see it. So let's get all three. So, Joyce over here.
You were speaking about global value chains or that value chains. Bringing on several points made by our speakers,
my presentation, as well as three groups, how best to keep trying to go forward. National level. So that in a way, to a large extent, our problem is much conceptual. We just don't know how to deal with the matter, right? Because national law has been interstate, right? Which is a ranking is big based interstate relations. At the same time, the market was not whatever it, right? It was the structure of the national law, right? Allow the market to operate the way it started to build since after the early glorious years, right? So we are totally right, either domestic or international, right? When I say international, I mean something between multilateral and contractual. Let's say maybe this is not going to be. I think as national lawyers and national lawyers should be no big deal. Yeah, maybe just with the way they think about action.
The other questions there actions.
I have a simple question to Naiki about the digital product passport. When I, we have the same issue with the digital product passport between the EU and Korea, as you pointed out, and I'm wondering whether the international standard setting bodies like ISO will be more proper forum to set the standards of the digital product passports and facilitate the trend, cross-border digital, cross-border life cycle information of the battery, information on the batteries or other products. Happy to hear your thoughts.
I think it was a third question.
Thank you for this really good question. Next question is on the methodology. Things that appreciate focuses on maybe something. So that's my story. It's just that. In terms of looking at law and choose whether or not image as a law infrastructure. So law is pretty much today. A lot of these boundaries describing a lot of things as infrastructure. Law as infrastructure, as we see issues with digital passports, contracts, arbitrations, and as a means of regulating suppliers and subcontractors, and to a certain extent, also securitization. This is rising from security politics as a means like law as regulating infrastructure, and then global value chains in a sense as being infrastructure, in a sense that a lot of governance movement is resolved identifying, capturing, and creating once those choke points have been created. Supply chain kind of governs itself because there's dependencies between upstream and downstream players, and players kind of self-apply themselves because dependencies that have been created. These choke points have been created by law in a sense, so it's just that structure as law or as law as it goes. Yeah, this is coming. This is just maybe invitation.
Well, thanks a lot for starting this up. Question. There's another question. Thank you.
Suppose I'm a research fellow at Center for Trade and Investment now. My question relates largely as the panel had diverse view and covered diverse topics. So in supply chain, we see multiplicity of regulations, largely dealing with the specific sector. For example, you see e-waste regulation, then you see EU's regulation on sustainable food system, then you have EU's critical material traces act. Similarly, US also tried to build something similar. There are many more. I think it's trade taking names. So do we see any harmonization? Is there hope that supply chain can be built together? And we also saw the examples in the panel of some bilateral instruments, plurilateral instruments like IPEF, and also labor instruments, which are also dealt under the IPEF agreement. So my question to the panel is there a way these issues can be put together and discussed in a harmonized manner?
Thank you. Thank you much for these questions. So, before first, Yoshiko, question was asked about the digital product passports. It's really actually this concept where this centralization.
Thank you for your question on digital passports and the reason what ISO. Yes, actually ISO is working, and I think we can also consider in other fields like AI or also critical mineral field. So ISO is working with steady standard. I think that ISO's work is a little bit undermined always, and so I think we should look for more on that. And there's two notes for that. So ISO, the question is who is working on. So it brings up in the middle ground. I think China is actually working on, and maybe in the case of additional passports, I think EU is also working hard. So even in ISO standards, there's the powers in that. But on the other hand, I often hear that ISO committees more, I would say, based on scientific or scientists world. So sometimes powers or the conflicts might be not so apparent, and they speak more, I would say, the detail with some science. So maybe there are two sides of the discussion, and in that sense, I really want to look at ICF.
Thanks a lot. So the other set of questions is very conceptual. So how should we think about international economic law with regard to the supply chains and especially supply chain that's emerged and we applied international to it with the more constituted relationship with infrastructures, self-regulate, regulate these infrastructures that we regulate differently. I think those questions are best addressed in political question. Rohan. Now, so I'm very curious about your thoughts when you think about those conceptual challenges your presentation debate between public and private, economic, your presentation on experimentation, different venues. So I'm curious about your thoughts.
Well, I'm just going to hold while we on those large set of questions we've got here. So thanks everyone for those. Now, when it comes to thinking about this infrastructure and thinking very much about how these different tools interplay with amongst each other, we have to, of course, remember again what does international economic law do in this sense, which is it very much sets terms of the game, conditions, market access, and border barriers, and of course, what other tools may be able to address have certain disruptions that might occur, given the wide range they take. Now, why does this matter? In a sense, it matters because global value chains are features of the market in the most direct sense. In other words, it's not like we're talking about corporation, that we have a legal form, where firms will adapt to that corporation. Instead, we have formations that have very well occurred based on various different types of interactions, usually formed through various contractual relationships or within a single firm. Now, why does this matter? Because international economic law, unlike, for instance, someone who's now in business of human rights, is essentially focused on these economic activities, where they are, how these direct moves happen. Thinking structurally allows us to then think a bit more ex ante. And using the example of textiles that I gave earlier, why was that influential? Because it showed us the regimes that had large scope in terms of the different types of products that they created. They had a very strong base of tools there, and there was an incentive for collective action. In other words, keeping all of trade within the GATT at that time. allow for a lot of these rules to be kept together and for it to very much shape the nature of textile trade overall. Now, what does this all mean in terms of all these other forms of governance? All of them, the public and the private, always will be an interplay. That's simply the nature of the interactions. Though value chains are not have only been seen as an objective at most within treaties, not really as an object in and of themselves. And that's why we'll always have that interplay happen. How we choose to set the balance here is an open question, and it's always going to be pluralism. It will differ depending on the context. We still need to think about what to start. And just a quick remark when it came to a point that Wolfgang raised earlier. Actually, textiles are a good example of a regime that was supposed to be exceptional for a certain period of time, but it kept on being extended. And that's perhaps an example of why we should be very worried about how we manage these exceptional circumstances, especially when thinking about these new areas.
So just a larger point, when we think about trade relations, trading relations, it's earlier, all the general theory had been that when countries open up trade, it would increase the size of the economic pie, and then the governments would have additional resources to redistribute them. But what we've seen is that there are spillovers of trade, some necessary, inevitable, and they spill over in a way that they affect both the trading partners. And the problem is when we try to address them with tools which actually exacerbate the problem. For instance, if US wants market access, additional market access in the economies or markets which have been protected so far, it is using tariff as a tool without realizing that countries do not have policy space in the first place to actually open up their markets. The domestic policy space, they need to have supporting domestic policies that support liberalization and tariff reduction. How do you create those policies? On the other hand, you have externally driven or top-down approach of enforcing external standards, form of say labor standards, which countries do not view positively. So it's time for a review where you look at things differently, where it has to be a cooperative arrangement, a collaborative arrangement. It cannot be a one-way or the other way. It has to work for both the parties. And in that sense, the example that I shared, EFTA-India agreement, is I think a landmark agreement in the sense that there is a commitment to actually create jobs through trade agreement, reskill or build skills in the investing country. And if the country is not able to fulfill, there is a rebalancing, remedial, can retaliate action. So this paves way for a number of similar arrangements that can be created on similar lines. And then maybe we have a new arrangement altogether.
Thanks a lot. So for the last round, moving thoughts, I want to pick up a question regarding the prospect for harmonization. So international law in general is sometimes a desire for making order, single undertaking. On the custody, we would say, well, maybe its fragmentation is not so bad. It's this pluralism, diversity, tangled legalities is the So in this spirit, I want to ask the panelists for your final reflections as to what kind of arrangements you think will emerge, because we've heard the full spectrum from unilateral to multilateral, from private to private public to fully public, from clubs and alliances to platform-like structures. So maybe starting with Amy, adopting this forward perspective, what do you think will emerge with regard to critical minerals? What kind of supply chain governance arrangements, Christian, do you think will we see? Maybe also differentiate between different supply chains, AI supply chains, different supply chains. Who's going to do the orchestrating that you want to see? Will the EU's approach really take on for building this resistance to active resistance? Which of the models that you highlighted, I think, has most purchase in the digital the trade economy to come. And finally, arbitration side, which has lived with competition and plurality of arbitration centers for a while. I'm very curious to hear your final thoughts. We'll go in that order that we start with him. And everyone has 1.5 minutes.
Thomas John is very nervous with time management. So I would like to begin by saying I would see critical mineral alliances and all this like unilateral measure as the phase where maybe one day we can head towards harmonization eventually, and these set of rules that hopefully integrates all of this concern that we're possibly having right now about critical minerals and global supply chain as a whole. But in the meantime, I think while we're heading there, I would like to pose a caveat, and that would be if harmonization is something we desire, or orchestration is something we desire, what is it that we're worried about with fragmentation? And in this specific case of critical minerals, what I would like to raise is the problem of who we're excluding with a non-harmonization, non-multilateral set of rules. And by that, I don't mean the foreign country of concern that people are trying to risk from. Like if that's something that's easily solved, we wouldn't be in this dilemma in the first place. But what happens to the developing economies that don't have as much bargaining power to initiate or to participate in this bilateral or regional dialogue and collaboration? And what happens to the country that let's say with not as critical or as valuable mineral reserves? Like, are they just like excluded from this new piece of pie that we just like we came up with, and will they just become eventually the victim of this new form of economic warcraft? And that's the problem I would like to raise. And I really like the question that was raised just now about the dynamic between global supply chain and law. Like, if I think what I would like to convey with this is, if we see global supply chain as something that's ever evolving in accordance with geopolitical tension, then can we also see international economic law as something that is living, that exists as a living organism that can actually follow up with the political or economic reality that we have in global supply chain.
Well, just to keep it brief and short here, if we're thinking about these harmonization efforts, their good depends on the aim. But now, just the slightly longer answer is that most current interventions have been done either unilaterally or on a bilateral basis when it comes to specifically focusing on the value chains. That doesn't really reflect the reality at all. You simply cannot focus on a single product within a macro with a very large domain. By using unilateral issues. Value chains can be broken up, they can bifurcate, they can simply just not have sufficient tracing at times. And oftentimes getting that accountability is quite a difficult one to practice. So getting all of these things together requires collective action. How does that work? Well, it really depends on the aims. We're not living in post-war Europe. You don't have the same bargaining chips within there. So, but you got to amend it.
Just quick one for, I think for semiconductors, sectors maybe sector agreements might be feasible. I mean, potentially a feasible way to bring together certainly a handful of like-minded challenges, and it could be solvable for the chance increasingly be common and next to everything. That's big thing. Having said that, I would say we should, that goes back to George's point. I think we should reconceptualize the idea of structured ecosystems, not just about state to state. It's more about, I think the insight from GL, you can identify where the power is. We actually exercise those national authorities and where what kind of issues that govern the global supply chain and rules through. You have the rules, and that goes back to Yoshiko's point in ISO. Actually, ISO is not traditional computer-based organization, but it has huge powers, effectively. Who actually excluded. I mean, in the past, China is not there, but now China is super powerful within ISO can sit still.
Thank you. One sentence answer to your question.
One sentence.
Yes.
All right, yeah, I agree that, fragmentation is not necessarily a bad thing. It creates new nodes of innovation and then if the way forward is a better ways of collaboration in the future. Sentence.
Thank you for playing along. Yoshiko.
Thank you. So, gross effects on countries, I think it may happen because it affects only few countries, Japan, South Korea, and China. But if goes to textile fabrics, I think it will cause a lot of confusion. So maybe it won't work. So that is the most impressive effect. But as Han-Wei highlighted, if we can include ISO into IEL, that's another after. And I would say in terms of fragmentation, this passport, as I mentioned, this was started from cooperation. So it's scientific community was pushing and there are lots of work. So I would say that infrastructure, I think infrastructure started first and you picked up as a legal concept and then a lot of competitions happening. So maybe infrastructure is pushing law and I don't know how much I can about that with the pushing that there was happening.
I would stick to there's no one size fits all approach. If that was the case, then I would have to single model step 5. So and even with 5, I was satisfied. I think something more. So, but end of the day, countries when they are in the economic relationship, they must be aware of the economic realities that cross transcend borders beyond that, maybe social considerations. And it can no longer because we are way past beyond the kind of stage where we talk about just tariffs. So we need to look holistically. Right? Social consequences of those economic realities are maybe good for a more collaborative.
Fragmentation is really a double-edged sword for arbitration. Arbitration now is still resilient to these conflicts because it's never centralized compared with WTO, but it definitely needs to be harmonized because it's simply not ideal if you can take one award to different countries and facing totally different judgments from different enforcing courts. So I will very simply say arbitration will definitely stay decentralized for maybe the longest period of time, but the effort to harmonize the national courts practice needs to be reinforced in the age of geopolitical conflicts.
Thanks a lot. Thank you everyone for this very resilient supply chain of ideas. And with that, I'll close the panel. Please join me in thanking the panelists and see you all at the live conversation. Thank you.
First supposed to be so good.
Yes. I just
Oh, yes, I would love the paper so much. It was so great and very good. I know so
I'm from
Nagoya.
When I met you. So I saw you. Citation, but I want to say, some people, but